Good evening, Professor, and hello, everyone. Welcome to Tax 600, Taxation Group Assignment. The topic of our group assignment is taxation advice on specific issues based on case studies involving a taxation issue supported by the IRAC method. We have selected 3 case studies for the task: Sanctuary Lakes Private Limited versus the FCT. Second, Walker versus the FCT. And third is Kale versus the FCT. Introducing the group members of our group with myself, Sneha Nair, Shilpa, and Kajal Verma. I will discuss the first case study topic of Sanctuary Lakes Private Limited versus the FCT, Federal Commissioner of Taxation. In the case Sanctuary Lakes Private Limited versus the FCT, the court has denied the deductibility of certain expenses for the claim of losses of the taxpayer on the ground that the losses are not related to the production of assessable income. Later on, the court provided the verdict that the losses were related to restructuring of the business. Therefore, the taxpayer is entitled to claim it under Section 8 of 1 of ITAA 1997. Sanctuary Lakes Private Limited is engaged in the operation of a golf course complex in Victoria. In 2003, the company entered into a restructuring agreement with its creditor as a part of the structure in the company that forgave $18 million as a part of debt payable to its members. Sanctuary Lakes has made it certain losses regarding the losses of its golf club membership. The Commissioner for the Taxation has denied the payment of accounting expenses, legal expenses, and losses, considering that those expenses are not a part of the ordinary business activities. Sanctuary Lakes was carrying on the business at the time of debt restructure and the sale of the membership. The next slide will inform about rules. In accordance with the provision of the Act under Section 8(1) subsection A, the taxpayer is eligible to claim the deduction if it is not relevant for the production of the income-producing activities. Section 51 of 1 of ITAA 1997 specifies that the taxpayer is eligible to claim for any deduction for running the business related to losses. The Taxation Rule IT 2199 suggests that the taxpayer can claim for the deduction for any losses at the time of carrying on any business or activity which produces assessable income. Based on the judgment provided for the Meyer Emporium versus FCT 1987, the Cloud has specified that the deductibility and necessity of the expenses should not be determined by the tax commissioner. Rather, it should focus on the quantum of deductibility. Hence, the claim for the expenses is deductible if it is related to the production of assessable income. Moving on to our next slide, which is applications. At the time of claim, Sanctuary Lakes was able to establish the fact that it had continued their business at the time of debt of restructuring and sale of the membership. Hence, the continuity of the business and expenses is available. Additionally, in referring to the relevant case FCT versus the Meyer Emporium 1987, Sanctuary Lakes has established the fact that these expenses are related to the production of assessable income because it is securing the business continuity. Another similar judgment is also provided for FCT versus Concrete Constructions Private Limited, which provided a clear judgment that the expenses for the restructure, which is related to the change of the nature of the business, will not be considered as an expenses deduction under the general deduction as specified under Section 8 of 1 in 1997. Rather, it should be considered as the capital expense. Conclusion. Hence, the Sanctuary Lakes has got the claim for the restructuring expenses and other associated costs, which the FCT has denied along with the penalty waiver. Thank you so much. The next case will be discussed by Kajal Verma.
Good morning, sir. My name is Kajal Verma, and my student ID is 20172-740. And I'm going to discuss about case study 2, which is Walker v. Federal Commissioner of Taxation, 14th March 2017. Now let's start with introduction. Walker has claimed for certain expenses as deduction under Section 8(1) of ITAA 1997 relating to the workplace-related traveling, which is denied by the FCT. Here, Walker, a registered nurse, has claimed that itself as itinerant worker, which the court duly rejects on the grounds that the taxpayer is having a permanent place of residence and traveling to different places based on a contractual basis. Hence, it will be considered as a home to work traveling expenses, which is not deductible under Section 8(1) of ITAA 1997. Now, let's move to the issues. Here, the issue is regarding the deductibility of the expenses which is claimed by the taxpayer related to the work related travel, meals, and their expenses because of the contractual work that the taxpayer is performing for which worker is required to travel in different places for the work. First one, taxpayer has claimed that those expenses are permissible and accordance with Section 8(1) of ITAA 1997. Here, the exceptions of the home to workplace travel expenses are not applicable in this given case scenario because the taxpayer is not residing at its ordinary home. Now, let's move to the rules. There are certain rules. The first one is consideration of Section 8(1) of ITAA 1997, where the taxpayer is eligible to claim in expenses which is necessarily incurred under ATO 2023. Secondly, in accordance with Section 1223A of ITAA 1997, the taxpayer is entitled to claim for the deduction of the meals and the accommodations if there residing away from the ordinary workplace because of the working purpose ATO 2023 in accordance for the taxation ruling provided under TR 99 by 12. It is specifically mentioned that the inherent workers are entitled to claim for the meals and accommodation. Now let's move to the applications. Under the application, the first one is based on the argument concluded by the Walker. The concept of itinerant is established in the front of the federal court, where the taxpayer is required to travel different locations for each engagement, as Walker does not have a permanent base of employment. Another one based on the ruling judgment provided by Jennings V. Commissioner of Taxation 1994 in order to consider a person as itinerant worker, certain characteristics are required to be followed. If the person is or the taxpayer is not considered as itinerant worker, it cannot claim for the deduction of the meal and traveling expenses. Additionally, in accordance with Section 1223A of ITAA 1997, the taxpayer cannot claim the deduction for private expense as deduction ATO 2022. Now let's move to the conclusion. To conclude, based on the judgment provided by the court, taxpayer is not considered as an itinerant worker, hence the taxpayer cannot claim for the deduction for meal and travel expenses. Thank you.
Hi sir, my name is Shilpa. Today I will discuss about the topic of KLV Federal Commissioner of Taxation 20 January 2017. It's a case study of third. During the financial year 2012 and 2013, the taxpayer Mr. Seppo Kale is employed with the Nordic Building Group PT Limited has filled their income tax return, where the taxpayer has come additional expenses for the overtrip meals where the overtime register is not available by the company whether the company has paid overtime to the employee. Here the taxpayer claim is denied by the FCT. Moving to the next slide. The issue. The claim for the deduction by the taxpayer relating to the overtime meal expenses is denied by the taxpayer by the FCT on the grounds that there is no overtime entitlement paid by the employer of the taxpayer nor the payments for overtime meal allowance. However, based on the arguments of FCT, the taxpayer's claims for the overtime meal allowance are denied on the basis that is not related to the production of assessable income. Moving to the next slide. The rules. Applications of Section 821 in accordance with the income tax return, with the Income Tax Assessment Act 1997 in expenses incurred by the taxpayer which is necessary for the production of the assessable income of the production of any business income will be considered as deduction. Taxation Ruling TD 2022 10 speaks about the taxpayer is eligible to claim the overtime meal allowance expenses amount should be reasonable. Taxation Ruling TR 2010, it is clearly stated that a meal allowance can be considered as a payment made to an employee to cover the cost of the meals during the overtime hour. ATO 2022. Moving to the next slide. The applications. Based on Wilson v. Federal Commissioner of Taxation 1988, the High Court has clarified that the employee is able to claim for overtime if it is related to the production of assessable income. Hence, in based on the judgment, the taxpayer is able to claim for the deduction as for the overtime meal allowance. Secondly, based on the judgment provided for Evans the Federal Commissioner of Taxation 1995, the taxpayer can only claim the deduction for overtime if the taxpayer is able to prove that the expenses is incurred during the course of employment at the time of generation assessable income. Moving to the next slide. The conclusions. Mr. Kale was not paid an overtime meal allowance under an industrial instrument or otherwise. The taxpayer had claimed a deduction which has false and misleading. The payment of an allowance was a construction and had no effect on Mr. Kale's gross salary. The taxpayer failed to take reasonable care to comply with the taxation law. The commissioner was correct to impose an administrative penalty at the rate of 25%. The tax shortfall amount arising from Mr. Kale's deduction claims for overtime meal expenses. The administrative penalty should not be remedied.
Thank you so much, Shilpa. Moving on to our next slide, which is recommendations on potential impacts of the tax return. This is with regards to all the cases that we have covered so far, considering the taxpayers as our clients. In the first case study for Sanctuary Lakes Private Limited, the case could have implications for how certain tax deductions or concessions could be treated. And thus it is necessary to determine any precedents such as the issues that are related to deductions, tax planning strategies, or property investments. Coming to our next client, which is Walkers, under the Walkers versus the FCT. This case has involved a disagreement over tax claims that were made by Mr. Walker, the taxpayer. The traveling and accommodation expenses to the workplace is not qualifying for the work-related travel. Rather, it is considered to be home to work expense. The implications of and the tribunal's decisions needs to be reviewed with up-to-date information on the tax precedents. Coming to our third case scenario, which is Kale versus FCT. This case might impact the tax treatment, and it could influence how income or gains from certain investments are taxed. In conclusion, I could say that the Sanctuary Lakes Private Limited versus the FCT may impact tax deductions and concessions, while Kale versus FCT case could influence the income or gains from certain investments under tax treatment of financial transactions. Thank you so much, Professor, for your time, and we hope you have a great evening ahead. Thank you.